Hello, everyone. This is Dave Raff, and we have a serious subject going on here today on this segment. And before we get into that serious subject, I'd like to introduce a lawyer that's representing one of our fine young people and that was in the Army, and this is John Maher. Hi, John.
Good morning, sir. Thank you so much for having me.
Well, it's a real pleasure, and we've had a chance to get to know one another for about an hour, and I'm just blown away with what this subject is about. And I want to say thank you to you for helping the Lawrence family out in this particular segment. But before we get into that, tell me a little bit about yourself, your history in the military, and how you've gotten to where you are right now.
Yes, sir. By way of introduction or background, again, my name is John Maher, and I've got 20 years of experience as an attorney. I've been practicing law from the state of Illinois. I was active duty in the Army for about the first 5.5 years of my career as a prosecutor in Germany with the 1st Infantry Division, and then down in the Balkans during the United Nations peacekeeping mission to prevent ethnic cleansing, and then progressed into the defense side of the house and became an appellate attorney. Came off active duty on September 6, 2001 to become a civilian in Washington at the Justice Department, but we were attacked, as you know, 5 days later, and I stayed reserve. Since then, I'm presently a lieutenant colonel. There's a couple of deployments, mobilized deployments to Afghanistan and to the Defense Intelligence Agency. And right now, I'm still in the reserve. By day, I practice law. I defend soldiers, and largely soldiers who have been accused of crime in combat or other offenses, in addition to running a small business in Chicago and in other areas. I also represent federal employees when there's disciplinary actions against them. So it's my pleasure to be with you here this morning, sir.
Wow. So 20 years in the military. So you've seen a lot of different scenarios out there, and you've looked at it from both sides. Plus, you served your country in war zones.
Yes, sir. Kabul, Afghanistan, Bagram, Afghanistan, and Kandahar, Afghanistan. At the time I was in the Balkans, thankfully there was no active hostilities. We were more merely a presence force to prevent ethnic cleansing from coming in from neighboring Serbia into Macedonia. But that was my first real world mission, and so it was a learning curve like no other.
Well, the serious subject, ladies and gentlemen, that we're going to talk about today is a young man and it's First Lieutenant Clint A. Lawrence, U.S. Army. Can you tell us what struck you to help this person with this case?
Yes, sir. I think there's several compelling reasons why the case is of great significance. This is a case where, in a combat patrol in Afghanistan, Clint Lawrence was a platoon leader, his second day on the job in the 82nd Airborne 473 Cav 1st Platoon, and they were at a strong point in Zare Province in Afghanistan, which is in the Kandahar Province, in the Zare District, forgive me. They were conducting a presence patrol where they left their combat outposts, and they were in a single-file route of march behind a minesweeper because the area was so dangerous. And they had to climb and bound up and down 6 to 8 foot grape berms to go into the nearby town, and their mission was to deny enemy sanctuary and conduct a presence patrol. Normally, there was testimony at Clint's court-martial that there was fire taken every day. Rounds came up range from historical firing positions. On July 2nd, 2012, Clint was immediately behind Private First Class Skelton, a former civilian police officer from the state of North Carolina who had been on the unit for the previous 4 to 5 months. Obviously, and they were engaging all the time with the Taliban and insurgent fighters. The day in question, PFC Skelton was on top of the Great Berm, and Lieutenant Lorance was below the Great Berm. PFC Skelton called out a threat, which he perceived as 3 military-age males, or MAMs, riding back-to-back on a single red motorcycle, approaching the platoon's exposed route of march. He called out the threat and fired his weapon, and later testified at his trial that he perceived the threat as justifying him to defend himself and the platoon pursuant to the rules of engagement. His fire missed. At the same time, Clint Lawrence got on the radio and radioed 2 gun trucks, which were providing support by fire in an overwatch position, and those gun trucks took out 2 of the riders and a third escaped. Shortly thereafter, the platoon continues its mission through and into the town, and reached the westernmost edge of the small village of mud huts, if you will, and mud structures. And Staff Sergeant Herman and PFC Carson are on top of the highest building, and they see military-age males bobbing and weaving in the great berms to the north. They're also perceiving what they think to be ICOM radio chatter. As it turns out, wolfhound intercepts, technology we use to listen in to the opponent, indicates words to the effect of there's Americans in the town, we have to do something to them. Staff Sergeant Herman and PFC Carson engage, take out two, and wound a third. The third that was wounded is Muhammad Rahim. He was recovered, and he tested positive for HME, which is homemade explosive devices, residue on his hands. Shortly thereafter, a lone rider, another motorcycle rider, he's detained. He tests positive upon detainment with HME on his hands. However, he's let go for unknown reasons. And Muhammad Rahim is brought to the Kandahar American Hospital where he's treated. CID, the Criminal Investigation Division, takes his statement, and then he's released after they obtain his bloody clothing and his statement. All of that information is in the Criminal Investigation Division file. And what really brought this to bear, I think, was after 1st Platoon engaged and killed the two riders and the third escaped, some soldiers said, hey, I recognize those guys. They're village elders. So that gave rise to, hey, do we have a civilian casualty incident here? Meaning, did we kill civilians as opposed to the enemy? That's one of the reasons why the case was very attractive to me. And when I first learned of it and was asked if I would participate, I was very happy to do so. And the more you get into it and study it, you draw upon your own experiences over in Afghanistan and the use of biometrics. The real challenge here comes down to four things that went wrong, I believe. First, nobody apparently disclosed to the defense, nobody being the prosecution, disclosed to the defense, the chain of command, the judge, or the jury, the fact that those individuals that were killed have biometric enrollment numbers, which links their fingerprints to bomb parts, which means they're IED makers and associated with grid coordinates where IEDs exploded and killed and wounded Americans. That, to me, is a very important fact that should have been disclosed to everyone. My thinking is, if it were disclosed to the chain of command, there wouldn't have been a court-martial because you have rules of engagement and compliance with PFC Skeleton, saying this is why I fired, and then you actually kill the enemy. So if you have ROE compliance and you kill the enemy, there can be no murder. Instead, you're doing your job as a lieutenant and as an infantry unit. Secondly, one of the main parts here is that nobody recognized that all of the individuals in the field that day were linked to one another. Their names are in the CID file. CID interviewed all of them afterwards. The challenge is Civilian Defense Counsel who came on, Civilian Defense Counsel who came on never interviewed any of the Afghans. These are eyewitnesses and victims. And his client was facing 2 charges of unpremeditated murder and 1 charge of attempted murder for giving that order and never firing his weapon and never seeing the target, but instead relying on his infantrymen. And not to interview the witnesses is an abdication of his duties and responsibilities. So those are some of the reasons why the case is particularly compelling. Ultimately, Lieutenant Lawrence was sentenced to 20 years confinement and a dismissal after having spent 10 years in the Army as an enlisted man. He was selected for the Green to Gold program, where the Army thought so highly of him, they sent him to college at Army expense to groom him to be an officer to assume positions of greater leadership and responsibility. And on July 2nd, he was only with the platoon for probably, we think, between 48 and 72 hours, because the previous platoon leader had been wounded by peppering shrapnel wounds to the face and abdomen when a bomb blew up very near where the platoon was operating. So it was a very dangerous area out there. Clint Lawrence had done a fine job as an enlisted man, had been educated, and was on his 2nd combat patrol when all this happened. And so my thinking was, there's something more to this case. And although the jury convicted him of murder, the jury never knew that the individuals that were killed that day were connected to bombs, which means they're diametrically opposed to the United States, engaged in deadly hostility. And on top of that, the fact that Lieutenant Lawrence never fired his weapon and never even saw the target.
It's just mind-boggling how you're defining that he is actually military prison there in Fort Leavenworth in Kansas. It's just mind-boggling
Yes,
to me.
July 2nd, he was taken off the line, and the entire platoon was put into a GP medium tent, and Clint was separated from them. And he was so new to the platoon, there really wasn't a time for them to bond or develop trust or anything like that. Meanwhile, the platoon had been in the action, if you will, for 4 to 6 months prior to this. So we could safely say that they were pretty close. The entire platoon was given statements and said, listen, you're all accused of murder, and fill out your sworn statement forms. And I could imagine how that must have felt with them. They're coming up toward the end of their combat tour, about to rotate back to the United States, and all of a sudden they're facing murder charges. So they make their statements, and again, Lieutenant Lawrence is separated from them at that point by the Army. And their statements are very consistent with one another. However, a judge advocate reads them and says these are inadmissible because no one was read their rights under Article 31B, which is the military equivalent, if you will, of Miranda rights. So those Miranda rights were administered under Article 31B, and everyone adopted their statement. So from that point forward, you now have the platoon pitted against the brand new lieutenant who they don't even know, and each of the platoon was ordered to testify against Lieutenant Lawrence, and each of the platoon was given immunity for any of their actions on the field that day. And there's another dynamic here too, sir, and that is about 3 months prior, and about 25 kilometers away, Staff Sergeant Robert Bales killed 17 civilians in their homes. And by virtue of that, we could safely assume that the senior leadership's concern about civilian casualties took on a greater level of detail, a pucker factor, if you will. So then I would imagine just a few comparatively months later, and up the road, if you will, you have another potential civ cas. So I think the combination of the fact that some of the soldiers on the ground recognized those people to be village elders, coupled with the fact there had been civilian casualties in the Bob Bales case not too far away in time, created a confluence of dynamics which resulted in this case taking off on a life of its own. And one of the terrible things, most tragic things, if you ask me, is not only that Lieutenant Lawrence has been incarcerated now for 3 years, but also not one of that platoon, first platoon, has ever been shown the biometric evidence to prove that, yeah, fellas, the people you killed that day, they weren't innocent civilians. They might be village elders, but their fingerprints are on bomb parts, which means they're village elders and bomb makers. And I think that would go a long way in many regards of first platoon recognizing, hey, you did your job out there that day. You didn't do anything dishonorable at all.
Yeah, and what I'm hearing from you, I mean, that for some reason, his defense, didn't bring these things up, and you've communicated in our prior communication that there was reasons from that individual why he didn't, but you are bringing that to the attention, and you're trying to get the president to allow this young man to be released from jail. I mean, that's our...
Yes, sir.
Go ahead.
Right now, Clint's case is up on appeal before the Army Court of Criminal Appeals, which sits on Fort Belvoir, Virginia. At the same time, Clint's request for a pardon has been on the president's desk for a while now. And, as of this date, as we're talking this morning, obviously Private Manning her sentence was commuted severely or significantly. And my thinking there is just that if you have that vast power of executive clemency, I mean, if you have Private Manning and you juxtapose Private Manning with Clint Lawrence, the thinking that I think is basic, and that is Private Manning did it. Private Manning admitted doing it. Private Manning released 750,000 classified documents. Private Manning has spent time in jail. Fine. However, if we now have evidence that Clint Lawrence, there's rules of engagement compliance evidence at the trial that PFC Skelton said, yes, I felt a threat so much so that I fired my weapon. And then we actually have evidence now in the form of DNA showing that those people killed were the enemy. So if you have a person who did it and a person who didn't do it by virtue of DNA evidence, which person do you let go under a pardon? I would say the person who didn't do it would be the better route.
Hands down. So, and you're fighting for that, and whether President Obama makes a decision on this or doesn't make a decision on this information can go now next to President-elect Trump's desk. Is that right?
Yes, sir. That is correct. As a matter of fact, if Mr. Obama declines to act, obviously the administration will transition and will take up efforts and renew them towards the new sitting president. Because the facts are the same. I mean, our facts of our case are not going to change at this point. In addition to the request for a pardon, we're still in the appellate process, too. And the appeals in Clint's case are two. And this might be legal mumbo-jumbo, but the main one is under the Fifth Amendment in a Supreme Court case called Brady v. Maryland, which requires the prosecution in any state or federal case to turn over, even in the absence of a defense counsel request, evidence that will tend to exonerate, exculpate, or mitigate against an offense. And here that never happened. And the reason it didn't happen is we don't know, but it never happened. And we believe that had the evidence that these identities and affiliations with terror of the deceased had been turned over to the chain of command and or to the defense counsel, the jury would have come to a completely different decision and it probably acquitted Clint. I mean, it would be very hard, nearly inconceivable that 82nd Airborne officers, all of them right shoulder patch combat veterans, and it was an all-officer panel that sat in judgment of Clint, had they known that there was rule of engagement compliance and we actually shot the enemy, I can't imagine them putting Clint in jail, finding him guilty of murder.
Yeah,
Duncan Hunter was on the radio not too long ago saying that Congressman from California, former Marine combat veteran, he said that Clint should get a Silver Star instead of a guilty verdict.
Wow. So
the second part of his appeal is the Sixth Amendment, and that's the effective assistance of counsel at trial. And the basis of that is, the main point there is counsel that was retained by the Lorance family, which is a very kind family from Texas and Oklahoma. And it was a lot for them to finance that operation, the defense, if you will. He did not interview the named eyewitnesses and victims in the CID report. And which is hard to really make me believe, or I think anybody should believe, the phone numbers of the Afghan people were in the CID file. They're still there. So it wasn't a stretch in today's day and age to call them, Skype them, or have the judge provide transportation for you to get over there and interview them. You're entitled under Article 46 to open access to material witnesses. And a victim is a witness. Haji Karamullah was the third rider who escaped. CID interviewed him. Muhammad Rahim was shot in the arm by 1st Platoon. CID interviewed him. They put the riders together with the second engagement I described, where PFC Carson and Staff Sergeant Herman found the enemy bobbing and weaving in the Great Burns on ICOM radios. So Haji Karamullah was the third rider, and he's linked to Muhammad Rahim, who was shot in the arm. So everybody's linked out there, the key players at least. And so Clint's appeal is based primarily on those 2 points. The Fifth Amendment, meaning that the government didn't turn over the evidence and they should have, and the Sixth Amendment is defense counsel should have interviewed the witnesses and the victims and did not.
There you go. That is, so you are making an official request for the president to pardon this young man.
Yes, sir. That's on file with the president already. We prepared that. And there's a dynamic there. A lot of times, if you look at what President Obama has done, a lot of the cases in which he's issued clemency, and if I may, clemency being favorable action, commutation of sentence being that your sentence is reduced or you're let out of jail immediately, and then a pardon being there's a pardon warrant placed against your convictions where your convictions are technically forgiven. Okay? So with that in mind, we've asked for that, and we've asked the president to disapprove the findings and sentence in Clint's case. The reason being is Clint's objectives are he'd like to get out and go to law school, and he'd like to use this experience to defend the constitutional rights of others. So if he has murder convictions yoked around his neck for the rest of his days, he could probably go to law school, and he could probably graduate with a JD, a Juris Doctor. But it would be a stretch for him to be admitted to a state bar and actually be licensed to practice law and use his experience to defend others with murder convictions. So that's why we've asked the president to disapprove the findings in the sentence. which is ultimately what can be done right now in the appellate courts, as well as the Secretary of the Army can do it. And, of course, the President can as well. It's within his ambit to do it under Article 2 of the Constitution.
And we're trying to give our audience a kind of a summary of the case for First Lieutenant Clint Lawrence. He's U.S. Army. He was in the Army for, I think you told me, 11 or 12 years up until when that event took place in 2012. And then within a year of that time, he was charged and in prison. Is that right?
Yes, sir. July 2nd, 2012, it was the date of the combat action, or combat patrol, when the engagement occurred. And he was court-martialed at General Court-Martial back on Fort Bragg by the Commanding General of the 82nd Airborne Division 1 year later. And he was issued a sentence of 20 years and a dismissal, which is the officer equivalent of a dishonorable discharge. We had a small clemency stage, which is unique to military justice practice, where the Commanding General who convened the court-martial can take initial action, can ultimately throw everything out if he or she is so inclined in a case like this. The general at the time, Major General Clark, he knocked 1 year off Clint's sentence. So Clint is serving a sentence to 19 years confinement, of which he served 3. He probably won't get into the look until another 3 years at parole, because under the present guidelines for parole eligibility in the Army correction system, you normally have to serve just about a third of your sentence in order to come up for a meaningful look, a good look. And again, in Clint's mind, being released from incarceration is not his primary goal. It's not. Having the convictions off of his record is his primary goal. And he's even said that. He said, John, I would do all the time I had to if they take the convictions away, because the convictions are going to preclude the opportunities for him to apply what his next steps in his God-given gifts to serve as a criminal defense attorney and protect others.
Wow. And you were communicating to me earlier that, with Clint in prison, just as soon as there's someone new that comes into prison, he's talking to these people immediately to encourage them to get themselves to raise the bar on their capabilities. I mean, he's asking them to go to college and read and study and to keep their minds active. So he's a true leader in a positive way.
Sir, yes, sir. I couldn't have said it better myself. And that's the thing. When you meet Clint Lawrence, you may have an image in your mind of what a convicted murderer doing 19 years in a federal penitentiary might look like. He's anything but that. He's clean-cut, he's sharp, he's articulate, he's well-mannered, he's self-effacing, he's humble, he has a sense of humor. He's gracious, very, very intelligent, and on top of that, unbelievably well-read. He reads The Economist. He's got a reading list that he's been going through since he's been there. A lot of people have been incarcerated and made better things in their lives. Gandhi, for example, and other people like that. But beyond that, what he does is he remembers his transition when he first came from combat to court-martial to prison, and how tough that was on him. And so he's trying to apply that lesson when the other fellows arrive with their sentences. A lot of them are very, very dejected and depressed, and they want to lay in their rooms and cry and that kind of thing. And Clint says, no, you've got to immediately enroll in your college plan. You still have your GI benefits until your court-martial is final. You need to enroll in college. You need to get on your PT program. Here's a reading program. There's other things you need to be doing. There's vocational programs here, spiritual development programs, there's religious programs. You have to keep engaged. You can't just lay here and feel sorry for yourself.
Wow.
And he even said to me at one point, he says, John, one of the ways I deal with it is I just look at it as another assignment. I say, well, at least nobody's shooting in here. So you have to laugh. That's a hell of a perspective, if you ask me, sir.
Well, and you mentioned to me earlier that you have been down to see Clint, over 15 times, it sounds like. So you know,
yes,
and you studied at Fort Leonard Wood, too, is that right? Or Fort Leavenworth, excuse me.
Yes, sir, Fort Leavenworth, yes. I've been to see Clint. I came on the case directly after his trial was completed, and that's another story I'd love to tell you in a second here. There's another dynamic there, but I've been out to see him. My home and my practice is centered here in Chicago. It was only about an hour flight to Kansas City and about another half hour by car up to Fort Leavenworth there. And so what's nice about being counsel is we don't have to sit in the visitors area where there's no privacy. We get to sit in a secure area in an office in the legal setting, and we're able to visit. The Army's been very good with providing access in that regard. No complaints. And I think that that's helpful because you have to know your client. Representation, people just bandy that term about, but, to really do it well, you kind of have to get in your client's shoes and try to get in his skin and walk around for a while. I think Atticus Finch said that in To Kill a Mockingbird. But it's true because, in order for me, for example, as lead counsel on the case among a team of lawyers and investigators, that to have to actually know what to ask for. For example, Clint would rather do time, believe it or not, and in exchange not have convictions hanging over his head for the rest of his life. Knowing those kinds of things help you better represent him. And I think developing a relationship, he's going to be a free man at some point, and he's obviously a person of character in my estimation. So I'm glad to know him. And then beyond that, there's ideas, and just from a discussion flow, other things pop up. So continuing that communication, that dialogue, I think, is not only good for the legal representation, it's also good for the person who's incarcerated. There's outside links, and you have something, you have hope, you have things to look for, you have anticipation, and the lights are still on. We haven't forgotten about you. And then also, of course, in my Army career, right before you become major or right after you become major, you attend the Command and General Staff College, and that's on Fort Leavenworth, and I completed that probably 10 years ago.
So you know the situation well, you know him well, and it really gets down to this very simple lack of follow-through of not talking to witnesses and understanding and reviewing the biometric information that was available.
Sir, if I could box it up for you and for the listeners into about 5 points here, I say it was a convergence of the following 4 or 5 factors. 1, Clint Lawrence never fired his weapon. 2, he never saw the target. 3, he was brand new to the unit. The previous lieutenant had been wounded and taken out of action. 4, the riders were recognized by some of the soldiers as village elders, which is accurate. Fine, that's your testimony. On top of that, Bob Bale's incidents had happened previously a couple months up the road, so there was a great concern about civilian casualties. Then you add in the fact that no one checked the biometric data, which is readily available on servers throughout Afghanistan that we've placed all over the place that are used probably dozens of times a day for offensive targeting missions as well as defensive missions and prosecutions. And then finally you add in counsel who didn't necessarily meet the standard. All of that came together, which places Clint Lawrence in the penitentiary.
And you request for the president to pardon this young man now, today.
Yes, sir. Yes, sir. As a matter of fact, when Private Manning's announcement came out, I wrote a letter to the editor of the New York Times. I'm very happy to share that with you, send it over to you. It's about 3 or 4 paragraphs, and it basically says, I'd be happy to highlight it here. It says, given the mercy you've shown Private Manning, I make the point that Private Manning's case is unlike Clint Lawrence's. Clint Lawrence, we have rules of engagement compliance testimony of record, coupled with the fact that DNA evidence says we shot the right guys. So there is no murder. So, Mr. President, although Private Manning admitted to doing it, committing espionage, we have evidence that Lieutenant Lawrence didn't do it. So what better place to lie your executive power? You put it with the guy who didn't do it. That's correcting a manifest injustice, I think. And then secondly, we contrasted the case with Edward Snowden. I said, you look at Edward Snowden, apparently he's being bandied about for a pardon or some sort of clemency. Well, his case, too, is not as deserving, if you ask me, of Clint Lawrence, and here's why. Edward Snowden released far more damaging documents and espionage than, apparently, Private Manning did. On top of that, he then left and fled the United States to a country that attacks our cyber system and tries to disrupt our fair elections and hangs out there rather than subjecting himself to the American criminal justice system, where Clint Lawrence never once ran, went through trial, went to court-martial, has gone to prison, is serving his time, and fulfilling his duty as a citizen and a soldier. So by virtue of these things, you may consider Private Manning, and you may consider Edward Snowden, but you contrast them with Clint Lawrence's case, and I ask, intuitively, you don't have to be a lawyer, who is more deserving based on those facts.
Amen to that.
It's as simple as the person who didn't do it gets the clemency.
And I'm going to ask this question, and it's just kind of a checks and balances in my mind. Did First Lieutenant Clint Lawrence, U.S. Army, did he have any type of record prior to that event in 2012?
No, sir. His record was exceptional. Like I said earlier, to be chosen to apply for and be selected for the Green to Gold program as an enlisted man, as a sergeant with 10 years. So the Army sends you to college at Army expense because they recognize your potential for greater responsibility and leadership, and then commission you into the infantry and send you to airborne school and air assault school. And Clint was on his way to Ranger School after they rotated back from Afghanistan. So he was well on his way. So his record was fantastic. And there's no disciplinary infractions, and there's not even lukewarm ratings in terms of being a non-commissioned officer and a commissioned officer.
So
we have all of those here. It is the anomaly.
And ladies and gentlemen, we don't know all the folks that would listen to this conversation today, and we just don't know who people know. So we're asking that if you know somebody that can help push this situation to the very front of President Obama's agenda to pardon this young man, please do that. I think that John has done an excellent job to fight for this young man, and we got to fight for him now because he served his country, and his country saw him to be a future leader, and then representation did not ask the questions to do the research to where that he never should be in prison to begin with. So,
sir, if I may, that's so kind of you to say, but for the record, I mean, it's not me, just me involved here. There's a whole team of people, both legal attorneys as well as investigators, and then supporters, private citizens who have taken up the cause and have actually helped defray expenses. There's an organization called United American Patriots just outside Greensboro, North Carolina. And their sole mission as a nonprofit is to defend soldiers and Marines accused of crime in combat. And it's headed up by Major Donahue, who is a Vietnam veteran, received a battlefield commission in the Marine Corps when his unit was shot up, and he was a senior man. And subsequently, after his infantry service, he went on to fly jets for the Marine Corps, retired as a major, as a maverick, and as he's sitting in his home, Haditha broke out right around 2004 or 5. I don't forget it. I don't remember off the top of my head. And he was just flabbergasted by how those Marines were treated before they'd ever gone to court-martial, hand irons and leg irons. And he said, what happened to the presumption of innocence? So he started this organization and to defend soldiers and Marines. And part of that is once the organization takes a client, that client is not just paying for lawyers and investigators and experts and depositions and things like that. No, they provide funds to the family so the family can travel to prison and visit with their loved one, their soldier, their Marine. Wow. They provide funds to the actual soldier in the penitentiary so the soldier can buy stuff, sundries and postage stamps and snacks and things like just to make their life a little bit easier. Or make subscriptions like Clint does to the Economist magazine. Clint's got half of his, they call them pods in the penitentiary there. He's got half of his pod reading the Economist. Some guys are looking at him like he's crazy. Because that can be some heavy reading at times, as you know. But in any event,
it takes a team.
To that, oh, yes, sir. And I have to say, I just might happen to be the person who's, talking about it right now, but without the input of our investigators who actually know the biometric systems, and without the collaboration of my colleagues John Carr and Bill Carney and Dick McDermott and Don Snyder, there's no way this thing could have taken off and got the momentum that it did, because candidly, I mean, each of us lent a different plank to the overall platform. And without a doubt, we've all been united, and we've become very tight, as you can imagine, over the last couple of years in fighting for this. Which leads me, I'd love to tell you the story about how Clint found us.
Love to hear it.
I don't know if you believe in Providence. I don't know if you believe in Providence, sir, but Don Snyder is an author. and he lives in Maine. He's probably 60 years old. And back in the mid-'80s, he wrote his first book that was published called A Soldier's Disgrace. And it was a true account of Major Alley, Alley, who was a combat veteran of World War II and a career Army officer, such that he was still in the Army when Korea broke out. Went over to Korea, but was captured by the Chinese. Spent considerable time as a prisoner of war with the Chinese, with other Americans. Was released, went to medical treatment. When he was fully rehabilitated, the Army court-martialed him for cooperating with the enemy. And they sent him to Lord Leavenworth Prison. And then a couple years later, in the middle of the night, they put him on a bus and released him quietly. Don Snyder met Major Alley in Bar Harbor, Maine, when Don was a cub reporter. And the next day, after Major Alley said, "Would you help me write my book?" Major Alley died of a heart attack. So Don became friends with the widow and wrote the book, and the book is called A Soldier's Disgrace, and it also dovetails into their attempts to exonerate and correct Major Alley's record. And so that book, believe it or not, just happened to be residing in the bookshelf at the U.S. Disciplinary Barracks, Fort Leavenworth, Kansas, when Lieutenant Clint A. Lorance walks into the library. He grabs it, reads it in 2 days, calls his mother, Anna, in Texas, says, "Mom, would you find this man Don Snyder?" So Don Snyder is found by Anna Lorance, gets on a train, funds a train ride from Maine all the way to Leavenworth, meets with Clint, and says, "Oh my God, this kid doesn't belong here." Then he takes the train down to Texas and meets Anna Lorance. And Anna Lorance is just a wonderful, wonderful, kind mom who's very concerned about her son who didn't do it, and he's being wronged. So she's looking for help to fight for him. Well, as it turns out, Don Snyder's very good friends with John Carr. And John Carr is an Iraq veteran. He's an Illinois attorney, and he and I have been good friends. We served in the Army together since 2004. And John Carr is also an Army judge advocate. So Don Snyder calls his friend John Carr, and John Carr called me, and then we had the team. And then we were able to reach back and draw upon my experience with biometrics in Afghanistan. And that brought the case into a different fold, if you will. So
Wow.
It all started back in 1983 with a book, a book on a bookshelf. And that's how it all came together.
I'm just amazed that taking a train from Maine to Fort Leavenworth. I mean, that's rare.
Yes, Don's a nostalgic, and Don's a little bit of an old school guy. You know, he'll still roll his own cigarettes, and he's a very accomplished author. I think he's got 12 books out there, but that was his first, and his first has brought this issue to bear. And candidly, it's a very strong case. I mean, I wish I could give you a prediction, but criminal law is just too unpredictable because there's too many variables. There really are. But of the cases I've seen in 20 years, and our entire team collectively is probably 150 years overall, you don't have a case like this come along too often.
Wow.
You just don't.
And good thing, but we got to fight for this young man. So I've seen a photograph of Clint, ladies and gentlemen, and we're going to have that's going to be part of the image for this segment, and you'll be able to see and look into the eyes of this young man, and plus the story that and the information that John has provided us and the history of all that will help connect why this young man needs to be pardoned. It's quite a story, John. I mean, I'm just missing
I tell you,
something
sir,
else.
there's another piece here I'd like to touch upon a little bit greater detail.
Okay.
And that is, when I first came on the case, the record of trial, if you could recall, I'm probably dating myself, what Metropolitan phone books look like.
Yes.
I don't know if we even have those anymore, but big, thick books.
Right.
And there's 12 volumes like that of Clint's court-martial record.
Holy.
And that's the transcript and all the investigation and the Allied papers and the sworn statements and chronologies and things like that are all part of it, as well as the findings, the motions, the jury deliberations, the checklist, and the judge's instructions to the jury to have a complete record there. So the first thing we have to do is roll up our sleeves and get through that, and not with a cursory reading, with a fine-tooth reading. And one of the things that jumped out at me was, why are these soldiers testifying against their lieutenant? You know, I haven't been in the service. You bond, and you look out for each other. I got your six, in other words, meaning I've got your back. So that was something that immediately I wrote down on the pad. I'm like, what? This doesn't make any sense. Well, then you get to the part where they were given immunity in order to testify against him. Well, that makes a lot of sense, right? Okay. But beyond that, why would they be willing to do it? And I think that what happened there was these soldiers, the big picture injustice here, was not one of them was ever shown the biometric evidence that the people that were killed that day were their DNA and their fingerprints were on bombs, bomb parts that had already detonated, and bombs that had not been detonated, but instead we defused them. And I think to this day, if I were to sit in a conference room with one or all of the 1st Platoon and slide across the table the biometric evidence link charts showing the grid coordinates of their biometric evidence, the deceased riders, their DNA being on bombs recovered at grid coordinates, and those grid coordinates are where American paratroopers have been killed, I think all of them would sit back with a sigh of relief in some sort of measure.
Wow. That's just, they didn't have all the information.
No, sir, they did not. And Clint was so new to the unit as well. And there wasn't that time. And as soon as this incident happened, as soon as the soldiers said, hey, I think those are villagers, the CivCAS signal went up. And at that particular time, I think that the train left the station before it was fully loaded.
Well, there you go. That's why, you take, like you said, all the years collectively with you and your team have not seen a case like this, and now you're trying to get him pardoned. And that's the key word here, ladies and gentlemen. This young man needs to be pardoned relative to the story that John's communicating with us today. Anything else that you want to get out there, John?
Yes, sir. If you'd like to learn more, of course, please visit your website. Please visit OPSEC's website with Colonel Jamie Williamson. And then United American Patriots has more information, as does a website that the Lorance family runs called freeclintlawrence.com. And there's everything that we filed in the case is publicly available. So all the information we've discussed today on our program is available on the freeclintlawrence.com website, to include the government's filings against Clint's case. So everything's there as a matter of public record.
Okay. Well, that's going to be very helpful for people. But the key thing here, ladies and gentlemen, we don't know who knows who out there. Let's get the word out to where the president pardons this young man. There's no comparison to others that have been pardoned. And there's been a lot. I saw some numbers the other day. I think he's pardoned like 1,300 people or something like that. Do I have that right?
Yes, sir. I think I saw that yesterday on the pardon attorney's website and the White House website. As you can imagine, we keep looking every few minutes this time. And
now, and of course, when President Trump is officially in office, then this is going to go to his desk as well if President Obama does not get around to it.
Yes, sir. That would be the natural course, of course.
Okay, ladies and gentlemen, this has been John Maher. He is a lawyer, been involved in the military for a number of years, representing First Lieutenant Clint A. Lawrence, U.S. Army, and this young man deserves a pardon. Let's fight for him. John, thanks for being on today, and thanks for all you and your team's effort on this for this young man.
My pleasure, sir, and thank you for having me, and thank you to your listeners.